right, so this class we're going to be discussing Chapter 7, where we're talking about leasing property. More specifically, we're going to be talking about how to select or laws that govern selecting a tenant. Before we get into the case law, I wanted to take a moment to read through this statute with you all. I think it's important that we spend some time dissecting it so that you can learn how to read and dissect statutes, as well as to pull out the important parts of it. So the statute I'm referring to here is the Federal Fair Housing Act of 1968. And it is reprinted from your book. So, and it is discussing Section 3604. All right, so as made applicable by Section 3603 of this title, and except as exempted by Sections 3606B and 3607 of this title, it shall be unlawful to refuse to sell and or rent after the making of a bona fide offer, or to refuse to negotiate for the sale or rent, or otherwise make unavailable or deny a dwelling to any person because of race, color, religion, sex, familial status, or national origin. Okay, so it's important here to note a couple things. Number one, we're talking both about the refusal to sell or to rent property. So it applies to both sale and renting property. For it to apply, there has to be a bona fide offer, meaning a good faith offer, that is made by the buyer or the lessee. And that lessor will have had to have refused that offer, or alternatively, they would have had to refuse to negotiate for the rental or the sale of the real property. Or they would need to otherwise make unavailable or to deny the dwelling to the person. So there's 3 different ways that you can qualify under 3604. And the first is found here. You can think of this as 1, 2, and 3. All right. Now note that this section only applies to race, color, religion, sex, familial status, which is essentially we're looking at here either married or unmarried. Oh, this is really small. Sorry. Oh, that's not great. Okay. We're looking at either married or unmarried or natural origin. Okay. So it also prohibits, so we're still going, it's still unlawful to discriminate against any person in the terms, condition, or privileges of the sale or rental of a dwelling, or in the provision of services or facilities in connection therewith, because of, and again, we have the same categories here. These are the same ones as above, right? So what does B say? Well, B is saying that you can't have different terms, conditions, or privileges that are based solely on the sale. So what it's trying to do here is to prevent charging more, for example, for women to live in an area than men, or for persons of a particular religion, or to have different privileges. So basically, it is trying to prohibit discriminatory conduct as far as terms go. So even if you allow somebody to live there you decide to charge them much higher rent than others. Okay, this third part, C, 3604C, is kind of the marketing or the advertising section. And this says to make, print, or publish, or cause to be made, printed, or published any notice, statement, or advertisement with respect to, again, here we're talking about the sale or rental of a dwelling that indicates any preference, limitation, or discrimination based on, now here you're going to notice we're adding in some categories. So we have race, color, religion, sex, handicap, familial status, or national origin, or an intention to make any such preference, limitation, or discrimination. So this, the advertising part of the Fair Housing Act that prohibits discrimination in advertising for the sale or rental of a dwelling covers persons who have a handicap as well as the protected groups in subsections A and B. Then it goes into more detail. So to discriminate in the sale or rental, or to otherwise make unavailable or to deny a dwelling to any buyer or renter because of a handicap. So again, here we're talking buying and renting. Because of a handicap of that buyer or rentor. Okay, so it is unlawful. Basically, we're still applying unlawful. So it is unlawful to discriminate in the sale or rental, or to make available or deny a dwelling to any buyer or renter because of a handicap of that buyer or renter. So what you'll notice here is that the protection for discrimination for sale or rental for a person, it's not that persons with handicaps are not protected. They're just protected under a different subsection here, whereas subsection A protects these classes. Here, subsection F1 protects persons with a handicap from discrimination in buying or renting a property. It goes on, and it's a bit confusing the way that the statute is blocked here. But see, F right here. Here's F1, F2, and F3. Oops. So each of these falls under F. So to discriminate in the sale or rental, right? Or it is also unlawful to discriminate against any persons in the terms. Again, so we see here the terms or privileges or the sale or rental of a dwelling, or in the provision of services or facilities in connection with that dwelling because of a handicap. So this might cover, for example, if there is a common place where people can rent it for events, or they can swim in a swimming pool, for example. These would need to be accessible to everybody, and you can't discriminate based on handicap. All right, so. And here also we're talking about terms and conditions, where we set up here terms and conditions, meaning you can't charge somebody more. For example, you can't have different terms in their lease just because they have a handicap. All right, subsection F3 for the purpose of the subsection discrimination includes. So that means that what subsection are we talking about? We're talking about F. I'm talking about all this here is subsection F. So for the purposes of persons with a handicap under subsection F, so F1, F2, we're saying that discrimination includes a refusal to permit at the expense of the handicapped person reasonable modifications of an existing premises, occupied or to be occupied by such persons, if such modifications may be necessary to afford such persons full enjoyment of the premises, except that in the case of a rental, the landlord may condition the permission for a modification on the renter agreeing to restore the interior of the premises to the condition that existed before the modification's reasonable wear and tear accepted. What does that mean? Well, a landlord cannot refuse to allow a person with a handicap to make reasonable modifications to their rental space at their own expense in a way that would allow them full enjoyment of the premises, and except for the fact that the landlord may require that the person with the handicap remove or restore the rental space back to the way it was for a person with an able body. All right. Subsection S3B, a refusal to make a reasonable accommodation in rules, policies, practices, or services when such an accommodation may be reasonable to afford such person equal opportunity to use and enjoy a dwelling. So essentially, reasonable accommodations need to be permitted even if they are at the expense of the person with the handicap. All right, so accidentally skipped over in slides. So we're still talking about leasing real property and creating tenancy. So we went over in detail the Fair Housing Act just now. But before we move on for a minute, I want to ask you, why do you think that some exemptions were adopted to the Fair Housing Act? Actually, let's hold on a second, back up before I ask you that question. There are some exceptions to the Fair Housing Act, which I apparently did not reprint in our slides, but if you go to page 449 in your textbook, section C, note C, you will see that it states that the anti-discrimination provisions of the Fair Housing Act do not apply to two types of property. The first type of property are rooms or units in dwellings that contain living quarters occupied by no more than 4 families living independently of each other if the owner occupies one of such living quarters. So these are owner-occupied dwellings. The second is any single-family house sold or rented by an owner if he does not own more than 3 houses and does not use a real estate broker or agent in the sale or renter. So for sale or rent by owner. Now I can ask the question. You're just going to have to bear with me today. So now we can ask the question of, why do you think that Congress adopted these exemptions in the Fair Housing Act? Exemptions for owner-occupied residences, so rooms or dwellings that are owner-occupied, or to the sale or rent by owner. Why do you think Congress adopted these exceptions? Well, it's difficult to answer this question, so I'm just looking for a thoughtful answer here. But I'm going to go over 3 arguments for why it could be that Congress made exceptions for these 2 scenarios. And the first could have been that Congress was concerned about the extent of its power to regulate. And while the Fair Housing Act was enacted under Congress's power to regulate interstate commerce, and if you have a larger unit that's not owner-occupied or for sale by an owner that's a larger unit, more than 4 units, then you are definitely more likely to be impacting interstate commerce than you would be for just a single owner-occupied or a sale or rent by owner. So it could be that that Congress was concerned that the law could be struck down as an overreach of power. The second argument could be that Congress was trying to strike a balance between preventing discrimination and privacy of current homeowners. The third argument could just be that it was a political compromise, and that they needed to make that compromise so that the bill would pass. Now, these exemptions that I mentioned here, they only apply to A and B of the statute. They do not apply to Section C. So if you remember, Section, let's see, can I go back here? I can go back, look at that. Okay. So they only apply to Sections A and B. They do not apply to this advertising provision. So again, those exceptions only apply to A and B. They don't apply to advertising. So my question to you is, why do you think that is? Why would Congress only make those exceptions apply to A and B, but not to the advertising subsection? Well, the answer could be because advertising is much easier to link with interstate commerce, right? So if an advertisement was placed in a newspaper or posted on a website, for example, both of these mediums are likely to involve interstate commerce. All right. So we discussed the Fair Housing Act. We dissected it. Now, before we get into the case, I just want to talk about why we have the Fair Housing Act, and how we can justify it given the approach we have had to property so far, which is really emphasizing the right to exclude, right? So let's do a couple of ask a couple hypothetical questions. So let's say we have this traditional right to exclude, right, where the landlord can exclude everybody for any reason that he or she wishes, or they wish. So let's suppose Professor X applies to rent an apartment that you own. Do you have to accept him as a tenant? Well, as a general rule, if we look at this common law approach to the right to exclude, it's pretty large, right? So this common law right is pretty large. And generally, you could say no. you would have the right to exclude another from your land, right? So let's say what are some good faith reasons you might have to exclude somebody. Let's say they have no income, no money to pay. Let's say they have 15 dogs, right? And you're leasing an apartment, right? So these are considered bona fide, good faith reasons why you might not rent to somebody. Now, what if you don't have a reason? Could you just refuse to rent to somebody just because you don't feel like renting to them? The answer here is generally, yeah, sure. You can refuse to rent because you don't feel like renting. You can refuse to rent because you don't like the types of novels that they read, right? You can reject them for that reason. So so far we have said that the landlord can reject for a good faith reason. The landlord can reject somebody for a frivolous reason. And the landlord can reject somebody for no reason at all. Right? That's acceptable. But the law does limit the right to exclude in certain situations. And so we've talked about one already, and that is the federal protection, federal and there's state protections too. But so federal statutes which prohibit discrimination. So we talked about the federal statute, but also note that there are state statutes. There might even be local ordinances that prevent from discrimination, okay? There's also two other situations, two other limits we're going to look at later on, but I just want to discuss them now so you can kind of see where they fit in. So there's retaliatory eviction doctrine will prevent or limit the ability of a landlord to evict. And there's also some state statutes which require good faith eviction. We're going to go over these later, but I just want you to have a overview, big picture. When, there is a very broad right to exclude. We've gone over examples. We've talked about Jacques and Shack, and generally courts will uphold this right for good faith, frivolous, or no reasons, but they don't allow for discrimination or retaliatory eviction or good faith evictions. All right, looks like I reprinted this twice. We're going to skip over. Okay. So in sum, when we talk about discrimination being prohibited, we're talking about the Federal Fair Housing Act of 1968 or any state statutes that prohibit discrimination in leasing or selling property based on race, color, religion, sex, family status, national origin, or handicap. So your book uses Nathamer v. Brenneman Property Services, Inc. as the case through which to explore the application of these anti-discriminatory laws. So let's go ahead and take a look at it. In this case, the plaintiff, Nathamer, was both gay and HIV positive. And he had applied to the defendant, Brenneman's Property Services, Inc., who were a rental agency to rent a townhouse in D.C. This here is a photo of the townhouse. And the plaintiff explained to the agent, a Brenneman agent, that his credit history would show some problems because he had to take on paying for the care of his partner or his lover who had died from AIDS 3 years before. But since that his credit had been good. Stevens, who's the property owner, rejected the plaintiff's application. Now, Nathamer then came back and offered to pay a second month's rent as security. Then he offered to provide a cosigner. And ultimately, he offered to prepay 1 year's rent. All of these offers were refused by Brenneman Property Services. So the plaintiff sued under both the Federal Fair Housing Act and the D.C. Human Rights Act, which was the state act that prohibited discrimination, housing discrimination. The trial court denied the defendant's motion for summary judgment. So let's talk about the motion for summary judgment. I just want to make sure you understand or remember from civil procedure that at this stage in the proceedings, the plaintiff is just trying to establish a prima facie case in order to avoid losing the case on summary judgment. So they don't need to prove the facts. All they need to show is that a factual dispute existed. Okay? And at this stage of the case, already 2 of the 4 elements of the prima facie case, both parties agreed were met. So there were only two elements that were in dispute. The first element that was in dispute in this case was whether the defendants knew or suspected that the plaintiff was handicapped or had a handicap. And 2, whether the plaintiff was qualified to rent the property in question. So those are the 2 elements that were in dispute for this case. We will finish up this case in the next video.